Hang on, I had my mic open.
Hello, Mr. Hartley. It's now 10:45.
Good morning.
I'm assuming everyone's back. I hope they are. It's very hard to tell when we're online. So we've received a summary statement from you. Mr. Allen's here. Good. We've received a summary statement from you this morning, I think.
Yes, you have, and I've kept it short and brief, and I'm hoping you'll appreciate that.
Oh, certainly. I just double check. Commissioner Dimmery's also got that, because I think we got it by email this morning.
Yes.
Yes, I have. I haven't read it though. Sorry.
No, that's right. I mean,
It's not a problem.
it is quite. I just had a flick through it. It is quite short. So if you could just run us through that, I think would be perfect. Thank you.
Very good. Yes, and I just note my apologies, as you think you see everything, but I have omitted to add summary statement in the heading, but I have I've amended that and sent it through to Tyler, and it will go on the record in the correct form. But I don't think Tyler's reissuing that, so my apologies.
No, that's fine. Yeah.
So just to very briefly recap and go through the summary statement. I'm obviously my evidence in chief and the summary statement relate to the two submissions from GNLC Limited and Bream Bay Village Limited. Bream Bay Village is the builder of the retirement villages within the southern sector. In summary, I've paid close attention to the evidence, in particular the evidence that's been prepared by Mr. Badham, which I largely supported in my primary evidence. And I did listen to all of the other expert evidence yesterday through the day and took that into account as well in just forming the summary statement this morning, which I did want to get on the table ahead of time. So very, very quickly, the two main areas for GNLC and Bream Bay Village is the southern sector. And those are basically the ones that are affected by sub-precinct D and the now sub-precinct E. It was F earlier. And I'm happy with those as they now stand. I'm also happy with all of the rules in those sub-precincts, and I note particularly the provision for retirement villages as a restricted discretionary in sub-precinct D, which of course is important to Bream Bay Village. And also the provision for visitor accommodation as a discretionary along, not along State Highway 15, but along One Tree Point. So those two are specific and are not provided for in the underlying zones. I'm also generally supportive of the approaches now to infrastructure, and I've taken on board the comments regarding wastewater upgrading, and I agree with Mr. Badham in that respect that my experience is that wastewater upgrades occur as required, or sometimes not when required, but the simple answer to that is development doesn't proceed until wastewater services are available, and that's the way it usually works. It would be nice if all of these services were, and for that matter roading, was ahead of demand, but my experience is that's very rarely seen because of the major costs of that infrastructure. And also my experience is often the major service and infrastructure providers do want to see some evidence that growth is actually occurring to justify and sustain that growth. So it is a bit of a two-way street. I believe that reverse sensitivity issues arising from State Highway 15, particularly in regard to BBV and GNLC, are appropriately dealt with. And I note that Mr. Ibbetson's evidence yesterday very clearly illustrated that the extent of the need for acoustic treatment of noise-sensitive activities such as dwellings, retirement villages, and so on, are all outside of where those activities are provided for, other than perhaps some noise sensitivity activities in the commercial area. And fortunately, good buffers are also provided, in my view, for both the existing retirement village and any future residential and retirement village development by commercial development strip a lot right around the periphery of State Highway 15 that would now occur. And also, obviously, with eroding itself, like as, for example, Warra Drive, which provide additional buffer. And in that respect, I think that covers those specific matters in my summary statement. I would also note, because I know this, but certainly this morning also, in discussion with the evidence and the experts from Waka Kotahi, I was involved, as I said, at my primary evidence with the development of the primary centre provisions, and they were both comprehensive and complex for various reasons. But that was a major transition in itself, because before that, the whole of this land was zoned business which was heavy industrial. So the transition into a mixed use activity base of residential, commercial, live over work activities, for example, and industry was a significant move. This change is one I think is a big improvement because I don't believe that the full industrial zoning which exists currently in the operative provisions is totally desirable, given the more sensitive residential and potential light commercial activities that would have to be traversed by heavy trucks and transport. So I believe this is a sensible transition again. But I would note, and I reference you to Mr. Badham's supplementary statement, where he set out the table of the changes in land uses. And I pick up on this particularly in regard to the comments that have been made by Waka Kotahi, and that is that under the operative provisions, there's nearly 38 hectares of industrial activity, no commercial zoned land, 50 hectares of mixed use, which is industrial in effect. There is provision in the mixed use zones of the primary centre provisions for live over work and retirement villages, as is evident by stage 1 retirement village that has been built. But there are considerable areas of commercial and industrial potential development in terms of employment. And then you look at the proposed plan change 150 provision. Again, there's now nearly 26.5 hectares of commercial zoning, which in my view is both a service and an employment zoning. And the 8 hectares of retail commercial. So there is still a substantial potential employment provision there of well over 30 hectares, 34 hectares of employment land. So it's not as if there will not be local employment opportunities, as well as obviously service delivery opportunities. And that is an important point. The other matter I'd like to identify, of course, is that there's already been stage 1 retirement village built, and that's of I think 87 units from memory. And although stage 2 has not yet been finally designed, and this is on the land that Mr. Badham identified in his evidence yesterday, that stage 2 is likely to be in excess of 120 units. mainly subject to this rezoning occurring, because otherwise it's an industrial zoned land, which is not an ideal zoning to be proposing that for. So that is in excess of 200 dwelling units, which I believe you'll be well aware, retirement units have a reputation for generating far less traffic movement than traditional residential. Something around 0.5, I think, is the way the development contributions usually apply. So if retirement village development and similar developments like that do occur, obviously the traffic generations that the Waka Katahi are concerned about will be substantially less again. So I believe those were both relevant aspects of those issues. I think that's probably all I've got, and I'm happy to answer any questions you've got or respond.
Commissioner Dimery, do you have any questions?
Thank you. Let's see. Mr. Hartley, one thing you haven't touched on is yesterday we had quite a bit of discussion about provision of open space in the plan change area.
Yes.
And I do note your support for the precinct rule for retirement villages as a restricted discretionary activity. And I note that has a matter of discretion related to relationship to street and public open spaces.
Yes.
But from our discussion yesterday, we were trying to understand how the provision of open spaces might occur, and were referred to the district-wide subdivision rules. Do these ever come into play for retirement village developments? Have you ever been required to provide a public open space as part of a retirement village development, or not?
No, and good morning, and no, I haven't, and that's obviously, well, not obviously, but that's often because, of course, retirement villages will provide community facilities. You regularly will see bowling greens, a community hub building. I don't believe there are too many tennis courts and so on, but generally it's the more passive community recreation. But those are generally the ones that are provided. Which is understandable given the demographic that they're designed for.
So, and that I do understand. So there's the private places, and
yes,
that you are a planner, not planning open space planner as such. But in terms of provisioning, do residents at retirement villages, I expect they leave the retirement village and go out into the community, of course. So do you have a view on one of the matters of contention is still how open space should be provided for in the entire plan change area? Do you have any suggestions for us, given that the residents of the planned developments will want to utilise these spaces? Is there any suggestion you have for us of how that could be done? Because the two options we have are evidence with indicative areas based on catchment circles from the Parks Department, and then a suggestion to rely on the subdivision district-wide rules as development occurs. I think are the two options.
Yes, and
interested in your view on that.
Yes, you'll note also in the primary centre, the operative provisions is actually a fairly large open space area provided. However, we did. I've been involved in preparing 2 or 3 resource consent applications since that under those provisions, and those are partly implemented. I think there are 6 dwellings in the northern area you might have seen in your site visit that were part of that.
Yes.
The rest hasn't been implemented from memory. They've got plenty of open space at the present around them. The way we approached that was to convert in the resource consent process into more linear open space, and so and I think that is actually a really appropriate way to proceed. If we're dealing with sports fields and the like, obviously you do need large spaces, and that's almost in my view, a sub-regional solution-based approach is required. This area may be one that needs that, or it may not be, and more spatial planning will throw that up. And my experience with those is they're more efficiently addressed. Those scale activities are more efficiently addressed at scale. And I was closely involved in developing, for example, acquiring and developing 20 hectares of land at Ariwa for sports fields and open space. And those are the scale economies that worked. So my view is that the open space approach in this overall development area would be likely best addressed through linear open space routes. And what I mean by that is that if someone from a retirement village is walking, or maybe in a mobile vehicle, travelling through to the town centre, which is only some 1,000 metres away, which is very close to the usual 800-metre walking distance we use. So, you know, it is only about 1,000 metres approximately from the town centre area to the far end of the potential stage 2 village. So we're talking 15 to 20 minutes for an able-bodied person, and probably 10 minutes in a motor scooter. If there were linear open space avenues or attractive streets provided for that route, and that might be some tree-lined paths or similar sort of landscape setbacks, I think that would be a potentially appropriate way to deal with open space, and could be, as Mr. Badham has suggested, dealt with on a application by application basis, rather than to try and plan where those particular open space routes should be at this point, because I don't believe that the development planning has reached that level of accuracy or planning. Yes, it's not to say that. Sorry.
Oh, continue. Sorry.
I was just going to say, it's not to say that might not be appropriate in some places for a small neighbourhood park on a corner. And again, I believe those decisions can be made during the pre-application and resource consent preparation for each stage.
And your experience, is there any sort of, does it depend how you cut up the development and stage it? So if it was done on a very small scale, it might be more difficult to achieve what you, or does that not matter? So does it depend how comprehensively and how big an area you do, how many bites you take, as to whether you get the outcome you're suggesting?
In my view, it depends. Obviously, the larger scale, the easier it is for an applicant and council to discuss those connections up front, early stages. If they're done more incrementally, it is still, in my experience, feasible to do that, provided the assessment criteria relating to subdivision and development are appropriately applied, both by an applicant and by the consent planners. And that can show where routes, if you're first cab off the rank, and it's obvious that there might need to be a connection because the streets don't provide that connection, then I think it would be legitimate for an applicant or consent planners at council to ask where those linkages are being provided to meet the Whangarei District Plan wider provisions or wider requirements for those.
Thank you. Sorry, just checking your evidence and Chief. I did have some other things in here. And then in a similar vein, you've touched on the your views on the wastewater capacity issue and your experience of that. And at your paragraph 35, you talked about doing a comprehensive integrated assessment for a larger scale development. And I suppose here it's a similar question I've just asked about the open space. Does that change if it's chopped up into much smaller incremental development stages? Does that make it any more difficult, or is it do your comments stand that, I can't recall what you said, sorry, but
yeah,
Yeah.
no, I think I'm clear on what you are asking me, and that's it. Again, it's an issue of I'm very experienced where there are large areas of zoned residential or urban land where there is simply not the wastewater capacity in various urban settlements to supply those. And apart from giving councils or Watercare, for example, in Auckland, a target in which they need to plan for to serve those areas, if they're zoned in an appropriate way and not out of sequence, then that does give them, I think, a stable planning footprint to determine what and how they're going to provide for wastewater services. And I think it was stated, I think Mr. Badham stated, it was, so it may have been you in questions, that a development of this scale doesn't happen overnight. It will take years to develop. And that does give lead time for both wastewater and roading infrastructure and other public infrastructure to be planned ahead of time. But at the end of the day, if you want to provide a development and you can't achieve wastewater services, that development doesn't proceed until those wastewater services are available. And that happens all the time. But I think the most important thing is to have a concerted and stable planning approach, which I believe this is doing, because this is really just another evolution of the existing primary set of provisions. It's more critical when you're proposing perhaps urbanisation of rural land that's not been done before, and I think that would raise different issues.
thank you. I think you've covered off my other questions. Thank you. That's all from me. Thank you.
Thank you.
I just have one, Mr. Hartley, but I think it sort of links to some of the questions Commissioner Dimmu was asking. So in terms of those linkages to the town centre area and potential areas of open space, for instance, we have the plan which shows the potential road network, which has you know, a new residential street chain, but also a number of indicative routes. And what's your sort of feeling about that? Are you happy with that's there, but apart from those roads being those routes being a permitted activity, if you choose to develop them in the way they're shown and where they're shown, I don't think there's any way of sort of insisting upon them as such. Although clearly, you know, there will be negotiations regarding that in the resource consent process. But what's your feeling about the status that's been given to those?
Yes, yes, and I mean, all of those, the ones with the cross sections are outside the. I just note this for your for you, that the BBV and GNLC land is not subject to any of the cross sections. They have, it has, there are cycleways indicated, which could of course be achieved in a number of ways, including narrowing carriageways and having painted cycleway areas, protected areas, as we see occurring elsewhere. So the key question, I guess, is the other cross sections, particularly, and I've thought about that, and I was thinking about that in relation to the question I was just asked by Commissioner Dimmery, and that's really that if these cross sections and road treatments are put into effect, and for example, traffic speeds in many places are 40 kilometres an hour or 30 kilometres an hour, which again is occurring in many places. In my opinion, those network connections have some potential as, if you like, open space connections, because they become a much safer and more enjoyable place to be for pedestrians and cyclists. And it would occur to me that if if I was applying with a developer for the development of land in those areas, and we were discussing how we provide for open space and connectivity, that would be part of that discussion. In other words, do you need to have a cycleway, walkway through a greened area between blocks when you might have a 30km/h well treed and slowed down street network, which you would feel safe and and confident of having your child cycle on, as opposed to the standard 50-60 km/h speeds we usually see on these sorts of roads.
Mm-hmm. No, thank you. That was my only question for you. Thank you. So, Commissioner Dimmery, you didn't have any more, did you?
May I jump in with a
Of course.
supplementary, please? So I've forgotten a lot of the discussion that does follow on from that yesterday around the retrofitting of the roads. So, for instance, we did talk yesterday about Waiwarawara Drive, which is next to the retirement village, and the future one, and how that upgrading would actually be delivered, because Mr. Allen made the point that council owns the road, it's already vested, it's not within the control of the applicant. And I expect that if this plan change was adopted and stage 2 of the retirement village proceeds, your client may not be intending to contribute to the upgrade of that road. So how might it be in reality actually delivered?
Yes, and I did note that in terms of that cycleway, that could potentially be achieved by not a dedicated cycleway, but a narrower road with a painted and slightly protected median division, or just painted, depending on what the speeds are and so on. I can tell you that just as an example, there is a connecting road between Warawara Drive and Pokapu Road, and that's a little road called Orua Road, because that would be a road between the two existing and potential villages. That would be, I understand, that would be traffic calmed and significantly altered to provide for easy access between the two villages. So that's one way where I believe the developer, in that case, Bream Bay Village, would take affirmative action, if you want to put it that way. The other matters or other installations are more difficult to achieve, I agree, and it is difficult. They are council-owned roads. The immediate approach that I think of is one of using the development contributions process to identify and fund the necessary upgrading. Now, whether those are particularly or specifically targeted, that's a potential way of doing it on the Marsden Centre. But obviously those are discussions to be held with the developers at the time of application. How are you going to provide some of these requirements now as part of this application? And you have those discussions between council in terms of funding. They can be done by obviously side agreements, or we'll do this while we're constructing that because it's cheaper. We've got the equipment on site, or it's done as a retrofitted approach with development contributions, as is still an opportunity at development stage.
So, in your experience, given you're providing planning advice on the next stage, are you aware of what the policy is for this area, and is there provision within the development contribution policy for, is that a component of it, transport upgrades?
There is transport, but
the existing policy.
Yes, I don't believe there's provision for this. Obviously, at this stage, it wouldn't have been implemented. I wouldn't expect it to be implemented yet.
So might there be a need to change the development contribution policy in the future?
Yes, I believe that's certainly one of the methods that could be undertaken, is that council in its next review of its policy, were these provisions to be operative, would institute those at that stage. Obviously, in that case, sooner the better, to make sure development didn't get ahead of it.
Thanks, Mr. Hartley. I don't have anything further on that one.
Thank you.
Thank you.
Thank you. Thank you for your help, Mr. Hartley. That's been really helpful. That's been useful, and I think that last point was an interesting one too. So thank you.
Thanks, Mr. Knight.
Okay, so moving on, we have New Zealand Refining Company.
Good morning, Commissioners.
Good morning.
Morning.
I just first wanted to signal to you a bit of an availability constraint with one of our experts, Mr. Chilton. He has an appointment to get to at midday. So I note that he will be available again after 1:30, after the lunch break, and just looking at timing, our preferred order was to have him go last in any case, in which case it may be that we call him after the lunch break, but if you would prefer to run through his evidence first before he has to go and do that now, then we're happy to do that as well.
I mean, I guess it depends. You've got 2 hours.
Yeah.
Do you think you're going to need 2 hours is the question?
Well, I think having sat in yesterday and this morning and just seeing the way things have been progressing, I think that we will likely use up the 2 hours. I've got about 10 pages worth of legal submissions to get through, and following that we've got Mr. Elliott from Finding NZ to give evidence, as well as planning evidence from Mr. Macefield before we come on to Mr. Chilton. So I think it is quite possible that we'll use up that 2 hours.
I mean, I think we'll be taking lunch. I mean, we'd originally planned 12:30, so I think we'll stick with 12:30 to 1:30, which sounds like, if that's going to be the case, that will work for you. So should we kick off now and assume that he comes back at 1:30?
Yeah, I think so. And obviously, worst case, we might have to slot him in this afternoon.
Yeah, that's right. Exactly. Yeah. Yeah. Okay. Let's see how we go then. So yeah, we'll kick off now then. We've had so many things come through the last 2 days. What should we be looking at?
So there were my legal submissions circulated this morning from Tyler.
Okay, let's have a look. So just bear with me a moment.
Yeah, no problem. I obviously don't expect that either of you would have had a chance to have a look at them either. So I do intend to read through them.
Yeah, okay. I'm not sure that I have them. Any email, did they come through, sorry, today from Tyler or yesterday?
That was this morning.
Morning.
Oh, sorry, it's from Ashley Middleton
Oh, okay, it's from Ashley.
at 9:20.
You know, that's all right. I was looking at Tyler's emails. Yeah, so we got those. Sorry for the delay. Yeah, got those. Yeah.
So like I said, I will take you through them in full, given that you wouldn't have had a chance to read them.
Yeah.
I appreciate that you both probably have some degree of familiarity with the layout and the refinery, and have possibly come across them in other hearings. So I'm conscious of that as well, and I will, where possible, just skip quickly over a couple of things, noting that following my legal submissions, Ryan Elliott will also give his evidence as a company representative.
Yeah, okay, just to confirm that we both have been on a site visit to the refinery as part of the Urban Services plan change hearings, so we're sort of familiar with the general layout, and I won't say that I really remember what the processes were or what it really meant, but I think we've got a reasonable understanding. Thank you.
Okay, great. So these submissions have been prepared on behalf of Refining NZ in relation to Plan Change 150. Refining NZ made a submission and further submission which focused on the potential for reverse sensitivity effects on Refining NZ's operations. Refining NZ's submission seeks that Plan Change 150 be declined unless proposed provisions are amended to adequately address reverse sensitivity. As I've said, we will call evidence from Mr. Elliott on behalf of the company, Mr. Macefield, who is a planning expert, and Mr. Chilton on the air quality effects. And this was all pre-circulated prior to the original hearing date back in August. So they won't be reading their full statements out. They are prepared with summary statements of their evidence to go through. So just a bit of background to Refining NZ. They operate New Zealand's only oil refinery at Marsden Point at the entrance to the Whangarei Harbour, and also own and operate the refinery to Auckland pipeline, which I'll refer to as the RAP. The refinery and the RAP are nationally significant infrastructure resources. Refining NZ is deemed a lifeline utility pursuant to the Civil Defence and Emergency Management Act. And Refining NZ is also a requiring authority under the RMA and holds a number of designations, including in the Whangarei District Plan. The refinery is a major physical resource, and through its operation of the refinery and RAP, Refining NZ is a significant contributor to the economic and social fabric of Northland. The refinery and the RAP are recognised as regionally significant infrastructure in both the Northland Regional Policy Statement and the proposed Northland Regional Plan, and the RAP has also been identified as nationally significant infrastructure in the NPSUD. The importance and benefits of regionally significant infrastructure are expressly recognised in the RPS and the proposed regional plan. These documents enable Refining NZ's operations as regionally significant infrastructure and provide for its protection, including against reverse sensitivity effects. The district plan and therefore Plan Change 150 are required to give effect to the RPS and not be inconsistent with the proposed regional plan. Refining NZ's operations involve a range of heavy industrial processes, which at times create objectionable emissions, including noise and odour. This is consistent with and anticipated by the heavy industrial zone. The evidence of Mr. Chilton addresses the potential for activities at the refinery to create air quality effects, including, in particular, odour effects from a wide range of activities and sources. The Marsden Point site was specifically chosen for a number of reasons, including the deepwater port access, availability of transport links, proximity to Auckland, and importantly, due to the surrounding environment. The land surrounding the refinery was considered to have a low risk of reverse sensitivity effects due to the lack of sensitive and residential activities in the area. As the Commissioners will be aware, Refining NZ is examining its future operations, and Mr. Elliott will touch on this in more detail. I'll just note that refining activities will cease next year, and the refinery site will shift to an import-only terminal for processed fuels. But it is important to note that the activities at the refinery site will continue to be heavy industrial in nature, and they are provided for by the Marsden Point Energy Precinct, which covers the refinery site. As the site moves to an import-only terminal, Refining NZ will remain an important infrastructure operator. So I'm just at my paragraph 12 now and going to cover off a couple of points on the statutory and planning context, which I'll just touch on very quickly. Relevantly, section 75, subsection 3D requires district plans to give effect to any regional policy statement. And subsection 4B of that same section requires that district plans must not be inconsistent with a regional plan. So it will be necessary for you to consider various competing policy directions in these higher order documents, and we do not intend to undertake the exercise here, but we do remind the commissioners of the strong policy focus on enabling regionally significant infrastructure and its protection against reverse sensitivity effects. To enable regionally significant infrastructure to operate free of unreasonable constraints is of strategic importance to Whangarei District, and in particular the context of Marsden Point, which has a heavy concentration of regionally significant infrastructure and heavy infrastructure in an appropriately zoned area. And there's a couple of provisions that I just wanted to highlight in some of these higher order documents. So just beginning with the regional policy statement, which identifies the RAP and the refinery as regionally significant infrastructure. The RPS recognises the risk of reverse sensitivity on regionally significant infrastructure and contains objectives and policies for the protection of regionally significant infrastructure against such effects, and the recognition and promotion of the benefits of regionally significant infrastructure. Relevantly, the explanation to Objective 3.7 acknowledges that regionally significant infrastructure may have adverse effects and recognises that such effects cannot always be practicably avoided or internalised. And I go on to just include a couple of excerpts from the RPS. I assume that you both have some familiarity with these documents, but I will just take you through these in any case. The RPS expressly recognises the potential for residential development and new subdivision to give rise to reverse sensitivity effects. And I've just included their policy 5.1.1e, which provides subdivision use and development should be located, designed and built in a planned and coordinated manner, which should not result in incompatible land uses in close proximity and avoid the potential for reverse sensitivity. And policy 5.1.3, avoid the adverse effects, including reverse sensitivity effects of new subdivision use and development, particularly residential development, on the operation, maintenance or upgrading of existing or planned regionally significant infrastructure. Another issue identified in the RPS is the lack of available alternative sites for regionally significant infrastructure. The explanation to Objective 3.6 notes, securing alternative sites for existing regionally significant infrastructure is extremely difficult. Mr. Elliott discusses the factors that were taken into account when selecting the site for the refinery many, many decades ago, including the low risk of reverse sensitivity. Therefore, it is vital that industrial zone land is protected against reverse sensitivity effects. The refinery and surrounding area is zoned heavy industrial, and as I mentioned before, the refinery is also protected by its own precinct. There are few, if any, appropriate alternative locations for the refinery and other industrial operators to relocate if such a response was necessary as a result of reverse sensitivity effects. And now I'll just move to the regional plans. So Northland has a proposed regional plan which does remain subject to a couple of ongoing appeals, but there are large parts of the proposed regional plan that I understand are now operative. In addition, there are a number of separate plans, and the key one here that we make some comments on is the regional air quality plan. The proposed regional plan recognises the refinery and the RAP as regionally significant infrastructure and includes recognition of the benefits of regionally significant infrastructure. It provides for the effective operation and its protection from reverse sensitivity effects. Policy D.2.5 requires particular regard must be had to the national, regional and locally significant social, economic and cultural benefits of regionally significant infrastructure. The protection of regionally significant infrastructure is provided for in Policy D.2.1, which states, when considering new use and development activities that could adversely affect the ongoing operation, maintenance, upgrade or development of regionally significant infrastructure, ensure that the regionally significant infrastructure is not compromised. In his evidence, Mr. Chilton discusses the relevant policies in the Regional Air Quality Plan and the proposed regional plan that highlight the importance of managing reverse sensitivity effects on lawfully established activities, especially in relation to air discharges from those activities, including regionally significant infrastructure. And he highlights that the air quality plan specifically focuses on the protection of industry in the Marsden Point area. Turning to the Whangarei District Plan itself, the refinery is located within the heavy industrial zone and is also covered by the Marsden Point Energy Precinct. The precinct applies to the refinery site and enables the existing and potential future operations undertaken by Refining NZ. It provides for the recognition of the refinery as regionally significant infrastructure and enables refinery activities as a permitted activity. And these are very broadly defined in the plan and include the use of buildings and major structures within the precinct for activities associated with the production, import, refining and/or distribution of energy products. The heavy industrial zone anticipates that industrial uses may give rise to objectionable odour. The district plan recognises that the heavy industrial zone has a lower level of amenity than other zones and should continue to be located away from more sensitive zones, such as residential, to ensure that adverse effects on sensitive activities are minimised, as well as to prevent reverse sensitivity and increased risk effects that may limit the operation and expansion of industrial activities. To support this approach, it is critical to protect industrial activities from the encroaching development of sensitive activities. In his evidence, Mr. Macefield comments on the importance of consistency within the district plan with reference to the District Growth and Development chapter. This chapter addresses significant resource management issues for the Whangarei district, including the protection of and efficient development and operation and maintenance of infrastructure. Objectives and policies in the District Growth and Development chapter address incompatible land uses and reverse sensitivity. Objective 5 requires the avoidance of conflict between incompatible land use activities from new subdivision use and development. And policy 2 is to manage the establishment and location of new activities and expansion of existing activities to avoid conflicts between incompatible land uses. The chapter also contains specific provisions relating to regionally significant infrastructure. These require the identification and protection of regionally significant infrastructure and recognition of its benefits. This chapter being the District Growth and Development chapter, falls within the district-wide matters part of the district plan, and the issues section sets out the objectives and policies, guide strategic direction making, and apply in addition to the objectives and policies in other parts of the plan, including Plan Change 150 if it's approved. The district plan clearly recognises the benefits of regionally significant infrastructure and the need to protect regionally significant infrastructure and heavy industry generally against reverse sensitivity effects, and it is important that Plan Change 150 is consistent with this framework. Moving on to some comments about reverse sensitivity. I'm just at my paragraph 23 now. In its submission, Refining NZ identified that it is concerned to ensure that the potential for reverse sensitivity effects from the spatial land zoning and increased residential focus and proposed density at the Plan Change 150 site are appropriately addressed. Refining NZ seeks that the proposed provisions be amended to adequately address reverse sensitivity as set out in the evidence of Mr. Macefield, and if adequate provision is not introduced, that Plan Change 150 be declined. And just to be clear, Refining NZ does not object in principle to the rezoning of the Plan Change 150 site. It is, however, concerned to ensure that the introduction or enabling of more intensive residential development should not be allowed to unduly constrain Refining NZ's current and future operations without appropriate planning controls. As set out above, Refining NZ's operations are heavy industry, and it's recognised that it will at times have adverse effects. Refining NZ makes efforts to internalise effects but acknowledges that this is not always practicable. Refining NZ operates in accordance with its suite of resource consents and other relevant authorisations, including a comprehensive suite of discharge consents recently granted by Northern Regional Council. And I'll just make a comment in here that while the refinery complies with conditions, that doesn't necessarily mean that there will be no complaints. For example, if you have a nearby receiver who is particularly sensitive to noise or odour, they may find odour objectionable enough to complain, even though the refinery is complying with its resource consents. And the refinery does receive complaints from time to time, which Mr. Elliott will go into in more detail as well. Refining NZ maintains a record of complaints and has processes in place to respond to and work with complainants. The Plan Change 150 site is some distance from the refinery, although this is not as far as being suggested by the applicant. So I just wanted to note there that there's some inconsistencies between the various evidence and legal submissions and application documents as to the distance between the refinery and the plan change site. And Mr. Chilton's evidence sets out that the distance from the closest point of the refinery to the closest point of the plan change site is 3.5 kilometres, and so that's the distance that I have referred to throughout the legal submissions. As discussed in the evidence of Mr. Chilton, in some conditions, there is the potential for residents at the Plan Change 150 site to experience effects associated with the refinery and possibly also other heavy industry operators at Marsden Point. And there's just that same comment on the proximity of the Plan Change 150 site. So I'll jump to para 27. There is evidence before the panel that operations at the refinery give rise to objectionable emissions, including at times beyond the boundary of the refinery site. Refining NZ has robust environmental management methods in place to manage odour and noise emissions, which again, Mr. Elliott will cover off. Nevertheless, from time to time, Refining NZ does receive complaints regarding both noise and odour. Figure 3 in the evidence of Mr. Chilton helpfully maps locations of the noise and odour complaints received over the last 10 years and the distance of the complaints from the refinery. A number of the complaints come from locations greater than 3 kilometres away from the refinery and as far as 6 kilometres. Furthermore, with regards to the applicant's acoustic evidence, which is the evidence in chief, acknowledges it is recognised that large industrial sites can at times attract complaints from receivers that are located significant distances from the sites themselves. It is understood that such complaints are received from time to time by the industrial land users at Marsden Point. And the report of John Stiles also states, Plan Change 150 will provide for noise-sensitive activities in areas exposed to potentially high levels of noise emissions of industrial activities in Marsden Point. So the Plan Change 150 site is located approximately 3.5 kilometres from the refinery, and even at that distance, there is a risk of complaints arising by those undertaking sensitive activities, including residents, in relation to refinery operations. Mr. Chilton highlights that this risk is potentially exacerbated by the high frequency of winds from the east to the northeast that would carry any odorous emissions from refinery towards the Plan Change 150 site. And I'll just note there, as was picked up by Mr. Badham's rebuttal evidence, Mr. Chilton's evidence refers to winds from the west to the northwest, which Mr. Chilton has confirmed was a typo in his evidence, and it should read east to northeast, and he will make that correction when he comes to present as well.
Thank you. Just stepping in here, in terms of the quotes that you've given at 29 and 30, are they entirely relevant, bearing in mind they're from acoustic experts, and we're talking about odour.
Well, I would say that the refinery does receive odour complaints as well as noise complaints, and they do have a concern about noise as well. Obviously, we have seen the supplementary evidence from the applicant on acoustics, and we have to that's before the panel as well, and yeah. The relatively low number of complaints, both odour and noise, received by Refining NZ can be attributed to both Refining NZ's dedication to its environmental management processes, but also to the existing receiving environment around Marsden Point, being largely industrial and commercial activities and farmland, with some holiday homes and the established residential area at Ruakaka, which consists of a limited number of sensitive receivers. The proposed increase in residential density at the Plan Change 150 site increases the number of sensitive receivers proximate to the refinery, and therefore increases the risk of complaints, which in turn increases the susceptibility of Refining NZ to reverse sensitivity effects and the risk of operational constraints being placed on the refinery. Refining NZ seeks amendments to Plan Change 150 to adequately address the potential for reverse sensitivity effects, including by amending the proposed provisions and by requiring no complaints covenants on the titles. The discussion on reverse sensitivity in the Section 42A report is limited to considerations of noise. Relying on the acoustic evidence of Mr. Stiles, the Section 42A report recommends several changes to the precinct provisions, and Refining NZ supports these changes insofar as they address the potential for reverse sensitivity noise effects. However, the recommended changes only partly address Refining NZ's concerns. In addition to noise, odour effects are a major concern and are a source of complaints from locations as far away and further than the Plan Change 150 site. The evidence of Mr. Macefield proposes further amendments to the Plan Change 150 provisions. This includes amendments to the issues section proposed of the proposed precinct chapter to acknowledge the proximity of industrial zone land and recognise that this may result in lower amenity. Mr. Macefield also proposes amendments to Objectives 6 and Policy 9, some of which have now been accepted and adopted by the applicant, which we heard from Mr. Batten yesterday and in his supplementary evidence. It is submitted that these amendments are appropriate to provide consistency with other district plan chapters, in particular the District Growth and Development chapter, and to better give effect to the RPS. Specifically in terms of no complaints covenants, and coming to my paragraph 38, in its submission, Refining NZ also sought that no complaints covenants be included on the titles as a measure to address reverse sensitivity effects. The use of no complaints covenants is an appropriate method to protect against reverse sensitivity effects and has been used in relation to residential development at Marsden Cove. In particular, no complaints covenants are useful for managing expectations for residents at the outset by putting them on notice of the potential for reduced levels of amenity, and in its experience, Refining NZ has found that to be particularly useful for managing those expectations, particularly where new residents coming into the area are not likely to be going and looking at the district plan provisions which relate to the reduced amenity and potential for reverse sensitivity. The applicant acknowledges that reverse sensitivity covenants have been imposed through district plans, and Mr. Allen referred to the AUP as an example of that. However, the applicant has not proffered the use of covenants in this case to address the potential for reverse sensitivity effects to arise. In his evidence, Mr. Batten asserts that there is no reasonable basis to require no complaints covenants. Contrary to the applicant's view, it is submitted for Refining NZ that there is evidence before the panel which demonstrates that complaints are received by Refining NZ from distances equivalent to the Plan Change 150 site, including from those residential uses. With regards to covenants, Mr. Stiles also commented in his report that they may be useful to ensure that expectations are properly set before residents or occupants buy or move into noisy areas of the site. We support the use of covenants on all residentially zoned sites exposed to outdoor noise levels greater than 55 dB LAQ, and he sets that out. And again, obviously, that relates specifically to noise. These recommendations were not supported in the Section 42A report, the reporting officer noting her view that there is no appropriate pathway to implement such relief through district plan provisions. Mr. Macefield endorses the position expressed by Mr. Stiles, explaining that the propensity of sensitive receptors to complain is related to their amenity expectations. Mr. Macefield recognises the validity of covenants as an effective resource management method. He has proposed a way to implement the use of no complaints covenants in the Plan Change 150 provisions by including an additional clause in Policy 9 as follows, which would be number 4, requiring no complaints covenants at the time of subdivision of low density residential, general residential and medium residential zoned land. With regards to odour, Mr. Chilton notes that the MFE good practice guidelines for assessing and managing odour identifies no complaints covenants as a measure for managing reverse sensitivity. And the Environment Court has found that the use of no complaints covenants can further mitigate potential reverse sensitivity effects, even where the distance between the conflicting land uses is considered to be sufficient to address reverse sensitivity. The amendments recommended in the evidence of Mr. Macefield to require no complaints covenants are an appropriate measure to protect against reverse sensitivity and should be adopted. Just a few concluding comments from me now. Refining NZ operations are recognised as regionally significant infrastructure in the regional planning documents. Activities undertaken at the refinery are heavy industrial in nature, and it is recognised that they will at times give rise to objectionable emissions. While Refining NZ endeavours to internalise these effects, it acknowledges that it is not always possible. Refining NZ receives noise and odour complaints from locations as far as 6 kilometres away, and therefore there is potential for effects on future residents at the Plan Change 150 site. Given the possibility of adverse effects to arise on occasion has been identified, Refining NZ's strong preference is to provide a mechanism to manage these effects before they arise. Therefore, it seeks provision for reverse sensitivity effects. One method Refining NZ has found useful is to include no complaints covenants on titles. Such covenants are useful to give notice to potential future residents that there may at times be a reduced level of amenity experienced. The evidence of Mr. Macefield identifies a pathway for including no complaints covenants on the titles, as well as recommending further amendments to the Plan Change 150 provisions to address reverse sensitivity. No complaints covenants together with robust planning provisions will achieve adequate provision for reverse sensitivity effects. Therefore, it is submitted that the relief proposed by Mr. Macefield be adopted. And I'm happy to take any questions.
Commissioner Demery, do you have any questions?
Thank you, Ms. Ellis. I think you may have heard the discussion yesterday with Mr. Allen regarding reverse sensitivity, and I note your comments just towards the end there about the Environment Court decisions suggesting that even when the distance is quite great between conflicting uses, that no complaints covenants can mitigate reverse sensitivity effects. Is there any guidance in those decisions about at what point how great that effect has to be that it could be in a potential reverse sensitivity effect? Because
no,
Mr. Allen was suggesting it as an effect, but not a reverse sensitivity effect. The effect was not great enough to create reverse sensitivity situation.
So
in
in
his
that case,
submission.
I understand the distance was, I think, about 4 kilometres, and that was between some proposed residential development and an airfield. Beyond that, there wasn't really any guidance as to when it may or may not be appropriate to include no complaints covenants as an additional mitigation measure. And I would also note that in that case, the no complaints covenants were offered by the applicant.
So one of the other things we discussed with Mr. Allen yesterday was even if there was a rule which was a trigger to change the activity status to discretionary, if there was no complaints covenant volunteered, a condition may not necessarily be able to be imposed requiring a no complaints covenant, if I understood him correctly.
And Mr. Macefield may be able to provide some further comments on this as well. But my understanding is that the plan could require the no complaints covenants, but the matter of enforcing the no complaints covenants once they have been entered into that's a civil matter between the parties, and that's beyond the council's authority or responsibility to enforce, but they can require the no complaints covenants in the district plan.
When you say require, do you mean by
provide for
a rule saying if you don't?
Sorry, go ahead and finish.
Sorry. So how do you mean the plan could require it? What would specifically?
Well, perhaps require is not the right word, but it could provide for a mechanism within the planning provisions to include no complaints covenants on the title.
And with the recent urban and services plan changes, can you refresh my memory? Is this something that was sought by Refining New Zealand and those plan changes?
No, it wasn't sought in relation to any of the zoning changes. I would note that the refinery did make some submissions in respect of zoning changes kind of proximate to their refinery, and those were ultimately resolved by way of consent order. But no, they didn't require, or they didn't seek that no complaints covenants were used in any of those instances.
So in relation to Marsden Cove, how have those been achieved? Is it not a requirement in the plan? What was the process that enabled those covenants to be put in place?
Perhaps Mr. Elliott can give some further comment on that as well. But my understanding is that that was a process of negotiation between the developer, landowner, and the refinery at the time.
Thank you. That's all I have.
Thank you. Mine sort of links a little bit to that one. Your paragraph 32, you talk about the limited or the low numbers of complaints, and you talk about the existing receiving environment, and you talk about some holiday homes in established residential area of Ruakaka, which consists of a limited number of sensitive receivers. I wondered how many sensitive receivers there were if we're looking at the number of dwellings within, let's say, a similar radius as the PC 150 area is to the refinery, and proportionally how much would the PC 150 plan change potentially increase that number?
Yeah, and I don't have those numbers, unfortunately. No. Again, Mr. Elliott may be able to provide some further detail on that point, but it's not something, I don't have that information in front of me, and it's not something I've specifically considered.
No, okay, thank you. I just wondered whether it was a limited number of receivers or whether it was greater than that, and proportionally what it meant. Okay, I see. I'll ask Mr. Elliott. Thank you. No more from me then. Thank you. So are we on to Mr. Elliott now?
Yes. And so, as I said earlier, obviously all of this evidence has been pre-circulated, and I take it that everyone has had sufficient opportunity to have a read through it. So I would just ask Mr. Elliott to run through a couple of key points rather than reading through his statement.
Okay, if you just bear with me, I've just got it up. So this is the evidence dated the 11th of August. Is that correct?
Yes,
Yep.
that should be right.
Commissioner Dimery, do you have that to hand as well?
Yes, I do. Thank you.
Right, yeah, thank you. Thanks, Mr. Elliott. We're in your hands.
Well, thank you for your time this morning. Given that you're both being familiar with the site, I won't go through the detail in the early part of my evidence. Most of the evidence is relatively brief. I'll just probably highlight certain key issues that are important to the current business and where we're heading and what we want to try and achieve for the future. So obviously you're aware that the refinery is going to become a terminal by the middle of next year. That will naturally reduce our, I suppose, emissions, both noise and also odours and other discharges to air. However, taking that on board and given the current changes in terms of the government's aspirations around climate change and needing to move to a low carbon economy, the refinery is looking at a number of options in terms of repurposing the site. As per my evidence, we are currently in negotiation around investigating the potential for production of what's called sustainable aviation fuels, SAF, on the site. Such processes will be quite similar in terms of what we have there today in terms of the refinery processes. So you will be generating heat, there will be a degree of odours on that site. Hydrogen and biofuels are also in the mix of potential reuse of that site. So it's key to us that we need to maintain our developmental flexibility as we move forward on the site in this time of change. And again, just within the context of a terminal, we are seeing quite dynamic changes at the moment and what might eventually formalise on the site in terms of tankage and other operations. We're currently in negotiation with parties around providing for a bitumen import facility, and they can be odorous at times. So that just gives you a little bit of context of where the refinery sits in the scheme of things. Moving forward, I'll just go over our experience with no complaints covenants, and we currently have there is currently one over the development of Marsden Cove in close proximity to us, and I do accept that it's closer than the current plan change area. We have over the years had a number of odour and noise complaints from the refinery, and this is where I'd like to sort of try and make a bit of a subtle distinction. Just complying with your consent is not always necessarily going to achieve what you need. What we see is that people have certain aspirations around amenity. The area is promoted accordingly. However, there's this decline in amenity, albeit even though we're compliant with our resource consents, and it's those are the matters that we currently deal with in some complaints. They come and go, and that's recognised. The reality is that where there's a clear identifiable source from the refinery in terms of either the noise or the odour, we will take reasonable steps to try and reduce those. We pride ourselves in being a good corporate citizen and working with our community. There are, however, times when these are either very expensive or the actual source of the issue, either noise or odour, cannot be pinned down or is just a generic emission from the site. And in those circumstances, if we have a particularly persistent complainant, the no complaints covenant does become useful to us at times. Not that we've had to use it all the time, but people are aware that it does exist, and they do appreciate that while we endeavour to minimise our effects, that there are effects in these areas. In terms of the extent of the complaints, we have had, as confirmed by Ms. Ellis, is the complaints as far away as 6 kilometres. If you want to sit on the end of Manganese Point, if you're familiar with the area on a calm morning, the refinery noise is quite evident. So that's the reality for us. And odour complaints recent ones at the beginning of this year were just under the 4K mark, about 3.8 kilometres from the site. And again, it's those calm morning that create issues for us. So that's the reality we work within, the perceived drop in amenity value, although we comply. That's pretty much the main points I want to put in to make to you. If you've got further questions, I'm quite happy to answer them.
Commissioner Demery.
Thank you, Mr. Elliott. I was just wanting to understand the Marsden Cove situation a little bit better, and how you came to have those no complaints covenants on that development there. Was it through plan rules or a notified resource consent, or how did it come about?
Look, it was before my time, but my understanding of it was that we appealed the actual decision to the Environment Court, and from memory, I think it was mediated as part of that mediation through before they got to the Environment Court, if I remember correctly. But again, it's before my time.
Okay. Is there any way of finding out that, out of interest?
More than likely, we should have some records around that. Ebony, you probably, Ms. Ellis, you've probably got the files in terms of our appeals.
Yes, I'll check something out.
Yeah.
So you've mentioned that even with the covenants, you do still get complaints, and what is your technique for dealing with that in that instance? What's the process?
Yeah, first of all, I mean, we sit down and listen. That's the main thing. Get a feel for the degree of concern, what the effects are, and then obviously in these areas, in terms of odours and noise, it's the detail that matters, because that's it's some of those details that allows you to be able to try and pin down potential sources within our operation, which are quite extensive and complex. It's those parties that tend to have, I suppose, a greater ability to describe and give us information around it, time, conditions in terms of the weather, and obviously wind directions is all useful. We work with them and keep in contact with them, and if we can identify sources, we'll tell them what it is. And at times we obviously need to be quite transparent in this. We can tell them either we can't, or one, identify the issue, or can't resolve the issue due to the balance between cost and source. So we generally work with them as much as we can. We do get unhappy people at times, but that's the reality of the issues. And certainly where there's no complaints covenant in place, we do point out that while we feel we're compliant, that there is a no complaints covenant in place, and people are people, you know, they have some are very accepting. They realise they bought the property with those in place, and others are not quite so accepting.
And so from what you're saying, even if the no complaints covenant wasn't in place, you do have a very good process in place to deal with issues, but your preference is to have a covenant, I suppose, as a last resort. Is that a fair comment? Or
yes, that's a fair comment.
To be able to point it out. I mean, not wanting to be too blunt, but you'd like to have that in your back pocket, perhaps.
Yes, as I said in my evidence, it's one of the tools in the toolbox, you know, and certainly, right. If for want of better words, push comes to shove, we have those in place. It's something that we can fall back on. Not that we prefer to do it, but it's something that is useful at times.
Do you have any idea of the covenants in Mr. Chilton? The complaints in Mr. Chilton's evidence? Out of those, how many times have you had to fall back on this kind of tool in the toolbox?
Probably twice. One a particular complainant, and it was around odours, and that loss of amenity. You know, we eventually had to say, you know, there's nothing we could do, and just reminded him there was a no complaints covenant on the title. Pointed out that in our opinion, and we offered that he could go to the relevant regulatory authority, that we felt as though we were complying.
And that leads nicely into my next question. How often do you get the regional council involved in terms of their compliance and monitoring team with your consents? Is that a common occurrence?
Not very often. We do invite the complainants quite frequently to go and take their complaint up with the regional council. We, as far as I can remember, we've never had the council come to us. They see us as a reasonably good operator and would leave us to do the investigation in the first place. And probably 9 times out of 10 we land in a good place. I'm not aware of the regional council actually coming out. The odours are such transitory matters that sometimes it's very difficult for them to even turn up at the right time.
Thank you. That's all my questions. Thank you for your assistance.
It's a pleasure.
Thank you, Mr. Reddy. I don't have any specific questions. I think I'm clear on what you've said, so thank you.
Thank you.
Thank you. So next we will move on to Mr. Macefield, who is hopefully about. There we go.
There we go. Good afternoon, Mr. Macefield.
Afternoon. Can you hear me?
Well, I can. I'll check with Commissioner Dimmery too.
Yes, thank you.
Thank you.
So I would just ask Mr. Macefield to read through the executive summary of his statement, and then we can go to questions.
Thank you, Miss Ellis. So taking experience, quals, etc. as read, moving to paragraph 6. Just making the point that recent plan changes throughout the district have really focused industrial and commercial activities into business zones to provide certainty. But if restrictions or impingements on those operations exist, it's pretty difficult to set up businesses elsewhere in the district now based on the planning provisions. And in paragraph 7, the Ruakaka Marsden area provides quite a proportion of industrial zoned land. In paragraph 8, there's policy framework providing that direction around incompatible activities and reverse sensitivity. And I note the amendments from Mr. Badham on the objectives and policies to link it more to the word avoid, which is positive. In terms of paragraph 9, Plan change 150 proposes to convert all the industrial zone land to residential, which is a bit of a change to that receiving environment, and a link there to Mr. Chilton's evidence, which you've heard alluded to so far, around the sensitivity of the refinery to residential activities. So paragraph 10, in my opinion, the MCP provisions were inconsistent, were a little bit better now with the RPS and the operative provisions for the District Growth and Development chapter of the now operative Whangarei District Plan. And then paragraph 11, some suggested changes and MCP Objective 6 and MCP Policy 9 appear to have been incorporated. So I'll just touch on the precinct issues section, and I won't read it out, but just make the point that management of expectations is, in my opinion, one of the key things to managing reverse sensitivity. And so the suggested wording to the issues section is one way to flag to current and prospective purchasers of the surrounding environments, particularly that light and heavy industrial land around the Marsden city area. Moving to paragraph 12, the evidence of Mr. Elliott, Stiles and Chilton supports the use of a no complaints covenant. And I do agree that it is an appropriate mechanism that could be used to give certainty around these effects and manage those expectations that I've identified. And this relief overall, in my opinion, will result in a set of precinct-specific provisions that are consistent with the District Growth and Development chapter, give effect to the RPS, and more effectively and efficiently achieve the objectives of Plan Change 150, and address the relief sought by Refining New Zealand. Thank you.
Any questions, Commissioner Demery?
Thank you, Mr. Macefield. Just looking at your evidence in chief, did you suggest any wording for the covenant provisions, or did you only suggest the changes to the objectives and policies? I did look at it some time ago.
Yep.
I had struggled to find.
In paragraph 73 on page 14.
So that's to do with the objective.
The policy MCP 09. It's the way the policy is written. It's quite prescriptive about the things that shall be done in time as the site develops to manage or avoid reverse sensitivity.
That amendment you've just pointed me to is an amendment to the objective, though. So is there, to carry this down in terms of through the vertical integration within the plan, are there amendments you're proposing to the precinct rules?
No amendments to the rules.
So if this objective was inserted, how would you see this being implemented?
When suggested, there was another one which has been removed now around a noise bund, I think to address reverse sensitivity for concerns from Waka Kotahi, that read something like at the time of future development, construct a noise bund. So in much the same way, and I don't believe that had any particular rule associated with it. So I was envisaging the architecture of that in a similar way. At the time of subdivision, the processing officer would consider that policy, and that's really the only time in the development cycle that you can impose an encumbrance on a title.
So you are much more familiar with the subdivision chapter of the Whangarei district plan. Are you satisfied that if it was restricted discretionary, there is discretion within those rules to impose such a requirement?
If there's a policy in there, then that gives the processing officer that direction.
So the matters of discretion, can you remind me, do they refer you back to the policies?
Yes.
Okay.
I can double check that, but I think that's the way the plan architecture works.
Thank you. That's all from me. Thank you very much.
Nothing else for me, thank you. Thank you, Mr. Macefield.
Thank you.
So that's it now until we have Mr. Chilton, isn't it? I think.
Yes, that's right. I did just want to make one last comment, which was in response to Mr. Allen's legal submissions yesterday, where he suggested that the refinery hasn't suffered any reverse sensitivity effects to date. And I just wanted to quickly comment on that point and note that obviously the refinery is subject to a suite of resource consents, and there's a whole bunch of conditions attached to those consents. So it's worth noting that at present the refinery doesn't operate free of any constraints, and including because of nearby residential and sensitive activities. The refining NZ does operate under certain constraints, including, for example, certain activities or processes that can only be undertaken in certain wind conditions, and even just considering the conditions more generally. So I just wanted to make that point in response to Mr. Allen's legal submissions.
Okay, thank you. Yeah, I've noted that. You don't think Mr. Chilton can be back till 1:30, or can he be back before that?
I will check with him. I have a feeling, unfortunately, it is 1:30.
Yeah. Okay, so on that basis, I don't know that we're really in a position to, because ideally we'd be coming back at 1:15, that's all. Do you think Mrs. Hicks would be able to be early?
Miss Hicks will not be here until 1:30. I can check in with Mr. Hood. I know that there were a couple questions potentially for him.
Good point.
He
Yes.
popped in at 1:15.
Yeah, that'd be good if that's possible. So we come back at 1:15 and see how we go. And then we're finished refining after as soon as we can, and then on to Miss Hicks.
Yeah, I'll give
Good.
Brett a call. Let you know.
Okay, fantastic. So we'll adjourn till 1:15 and see how we can move forward there. Hopefully. Great. Thank you all. Okay, so we're now adjourned to 1:15.